Hi, good afternoon, everyone. This is Ifama Odolami, immigration attorney from the Odolami Law Firm. And today I want to talk about a really important news that came in. And this is for people who are in immigration proceedings, deportation proceedings. And so I'm here to talk about the new memo that came out April 3rd and which is being enforced starting April 25th. And so this memo which is dated April 3rd, is a USCIS memo, is a memo from DHS talking about giving guidance to ICE attorneys regarding the enforcement of civil immigration laws and the exercise of prosecutorial discretion. So for those that don't know me, my name is Ifama Odolami. I'm an immigration attorney in New Jersey. My firm serves clients in all 50 states. I'm here on YouTube, Facebook, and Instagram, and I have a really great topic. I'm not going to be here long because I have a meeting, but I just wanted to share this really good news. And if you know somebody who is in deportation proceedings, or if you are in deportation proceedings, then listen in because this is really important information, and this could actually make a difference to you getting your green card. So basically, the Department of Homeland Security, the Secretary of Homeland Security, who is Alejandro Mayorkas, issued a memorandum April 3rd, 2022, basically discussing prosecutorial discretion. So let me explain what prosecutorial discretion is. When you are in immigration court, right, there's a prosecutor, which is the ICE attorney, and their job is to present a case um, why you should be deported based on you breaking certain immigration laws, right? So you should get an attorney if you're in immigration court. Really important for you to get an attorney. So if you're in immigration court, right, you're in immigration court because DHS is alleging that you've broken some immigration rules. So now, because of limited resources, right, limited government resources, uh, Secretary Mayorkas has decided by issuing this memo that ICE attorneys should pretty much enforce only priority cases for deportation. So this is really good news and is really important. I'm going to break it down for you. So DHS has pretty much indicated that deportation cases, right, are going to be, put into two categories. There's priority cases, right, and then there's the other cases that are not priority. The priority cases are cases that DHS is going to continue to prosecute, right? They're going to continue to enforce them, and they want to continue the case, and they want to deport the person, right? And the non-priority are the ones that they're not going to bother themselves with. And I will come to the second part in a little bit. But let's talk about the priority cases. Now, the priority cases that DHS ICE attorneys are going to continue to enforce are cases of threats to national security. So this is defined as a non-citizen who who is engaged in or is suspected of terrorism, espionage, or terrorism related or espionage related activities, or who otherwise poses a danger to national security. This person is a priority for apprehension and removal, right? Now, the next ladder of priorities will be the threat to public safety. So the threat to public safety will be a non-citizen who poses a current threat to public safety because of serious criminal conduct. And they are a priority for apprehension and for removal. However, the guideline says that this decision will not be made according to bright line rules or categories, which means that they're not just automatically going to deport you because you committed a serious crime. So they're saying that it requires an assessment of the individual and the totality of the facts and circumstances. So what this means is that your lawyer may be able to get you, get you from this priority list and if they can make a good argument as to why you should not be deported. So unlike the first category, the threat to national security, which is really a bright line rule, if they find that you are a threat to national security, you're going to be gone. But if you've committed a serious crime, there is room to, if your lawyer can convince the judge or ICE in this case, because they're looking to close down looking to close some of their cases. If they can convince ICE not to go along with it, then you're in good stead. Now, the third priority case, which is the one that a lot of people will find themselves in, is a threat to border security. So that would be a non-citizen who poses a threat to border security because they are apprehended at the border or port of entry while attempting to unlawfully enter the United States, or they're apprehended in the United States after unlawfully entering after November 1, 2020. And under this category, they talk about people who have committed serious immigration fraud, which threatens the integrity of the immigration system. So they're talking of people who have committed marriage fraud, people who have provided fraudulent documents, people who have been engaged in frivolous asylum claims that have resulted in a frivolous asylum bar, and people who have made false claims to citizenship. So false claims to citizenship is basically somebody who has claimed to be a U.S. citizen either when they were filing for employment, or maybe they've voted, or they've taken benefits that are not that only given to people who are U.S. citizens, or they've used somebody else's passport and pretended to be a U.S. citizen. So basically, for this category, ICE attorneys are saying that they will deport these people. These are not people that they're interested in keeping, closing out their deportation cases. So we've talked about three types: the threat to national security, the threat to public safety, and the threat to border security. So again, with this type of the threat to border security, just like the threat to public safety, there is there is some flexibility with regards to whether an attorney can convince ICE attorneys that they should not proceed with deportation, except for the four categories I mentioned, which is the marriage fraud, the asylum bar, false claims to citizenship, and all that. Basically, for those sections, ICE is saying that they're not interested in closing out the removal proceedings. So let's talk about the people who are in the non-priority group. That's pretty much anybody else. So if you're somebody who is in immigration proceedings and you're not a threat to national security, you're not a threat to public safety, right? And you're not a threat to border security, and you're in immigration proceedings, basically this guideline is saying that ICE should, consider removing this case, closing these cases out, because the government wants to prioritize the people who are in the priority list. So the non-priority list are people who you have a removal order, but you're eligible to adjust status, maybe because you're married to a U.S. citizen, or you have a child as a U.S. citizen, or you have a VAWA case, or a special immigrant juvenile matter case, or a T visa case, or a U visa case. You have another way to, you're eligible to adjust your status because you have an alternative relief, but you happen to be in immigration court. So if this is you, what this memo is saying is that your case could be closed out, and you may be able to proceed to get your green card, right? So a lot of my clients are in this category of people who are in removal, but they're able to adjust their status because there's a relief available to them. So if you're one of these people, call my office. We can assist you. There's also another group of people who are not eligible to adjust status because of the way they came in. Maybe they came in through the border, so they cannot adjust their status here, or because they have unlawful presence. So those people need to file a waiver. So for those people, if you're in deportation proceedings, you can request to have the proceedings administratively closed so that you can go, you can, if your waiver is approved, you can go outside the country and get your, attend your interview at the U.S. Embassy abroad and get your, and be able to come back into the country. And then there are other people who may not qualify because they have no relief available, or they don't need to file a waiver, but they're just not an enforcement priority and they want the case to be, their deportation case to be closed. That's also something that can be done based on this memo. So this is really, really, really great news for people who are in deportation proceedings. And if you're not sure if you would qualify, then talk to an attorney, because there's some people that want to be in removal proceedings because they can get a green card. For instance, if you have an asylum case and you're in removal proceedings with a defensive asylum case, you don't want to close your deportation proceedings because you're going to get a green card, hopefully, through that process. So, hi, Clark. Our phone number is 973-993-1900. Hi, Rachel. How are you? Thank you guys for tuning in. I wanted to do this really quick because I have a meeting at 1:15, but I had just read or rather, skimmed the memo really quickly, just so I could give you guys this information, because if you can get out of deportation proceeding and it helps you, you should. And this is a good time to do that, because according to American Immigration Lawyers Association, AILA, the ICE is looking to close as many as 700,000 cases. So don't be left behind. We can assist you. My office does this all the time. We've assisted many people in terminating we filed a joint motion to terminate the removal proceedings, and they're able to get their green cards once they get out of removal proceedings. Again, the number to call us is 973-993-1900, or you can go to my website, www.udalamilaw.com, and you can self-schedule to talk to me to see whether you may qualify. So for everybody else, feel free to share this video with anybody that you think may benefit from it. And even if you don't know if they're going to benefit from it, just share it anyway, because you never know who needs it. Follow us on social media, Facebook, Instagram, LinkedIn, TikTok, and what else? Whatever social media, so that you know when I come in with my videos. I'm sorry this was so rushed. I could barely keep up with my own thoughts, but I gotta go. It was so nice being here with you guys, and it was so nice bringing good news. So we'll talk soon. Take care.